All right. Well, welcome and thank you to everyone for joining us tonight for estate planning, probate, and guardianship. So this is part one that's presented to us by Bryana crossfiend. So we are super excited that she is here with us and gonna present for us. And I know she's presented in some other things in the community and has had rave reviews. So we're excited for us to come in support cancer support community today. So with that said, just want to introduce briefly, we have our cancer support community team on today, including Eunice, Katie, and Abra, and myself. So we're happy to be here again. And through our partnership with Cancer Support Community, Cancer Support Community is one of the largest worldwide nonprofits that provides free support for anyone who's been touched by cancer so that no one faces cancer alone. And through that, we're able to provide workshops like this today, as well as educational workshops with providers in the community, support groups, resources, and social events. So thanks for joining us. And I know we're going to have more coming up, and Abra will kind of go over those at the end. Just a little housekeeping. So we always recommend that you keep it at speaker view. So at the top right corner of your screen, you can change your Zoom settings to speaker view. It just kind of allows you to stay focused on the presenter and what they're presenting on the screen. Brianna's going to take questions at the end. So if you do have kind of like a burning question, you don't want to forget about it, go ahead and put it in the chat box. That chat box will be monitored, and then we'll make sure that your questions are addressed towards the end. And I think that's it for housekeeping. I'm going to pass it to Eunice, and she's going to introduce Bryana and take it from there.
Thank you, Caitlin. We are very excited to offer you this workshop on a topic that affects so many people. I want to thank Attorney Bryana crossfiend for graciously accepting to present for us tonight. Attorney Bryana crossfiend's primary practice areas are estate planning, long-term care planning, elder law, and probate. She also does small business formation and a real estate contracts. She has been a practicing attorney in Washington since 2013 and has had her own practice since 2014. She centers her practice around helping clients plan for the future by anticipating problems before they occur. Bryana currently lives in Bonnie Lake with her husband, children, and pets. She enjoys gardening, hiking, and spending time with her family. Please join me in welcoming Bryana.
Hello, everyone. Thank you so much for attending and having me today. You see my slides, and I'll just be going through everything today. And Eunice did a great job with introducing me. And sorry, I need to be smarter. Oh, there we go. All right. So as Eunice said, I've been a practicing attorney for about 8 years. I came out of law school kind of at the worst possible time with the recession, and so people weren't hiring, and I decided to hang my own shingle and become my own boss. That has worked out really well for me. I think I'm just better suited to it, and I think I probably would have ended up here anyways. So I have two offices. My primary office is in Puyallup, and then one day a week I am over in Gig Harbor. So I cover the great majority of Pierce County, and I've gotten really good at Zoom. So oddly enough, I'm getting more clients who are kind of outside of Pierce County, and we're just doing everything via Zoom, and works out just fine. So my contact information, my phone number and email is down here. And if anyone would like a copy of the slides, just shoot me an email and I would be very happy to get that to you. Now, I will be on this at this presentation primarily focusing on estate planning, probate, trusts, and a little bit of guardianship. My next presentation on April 20th is when I am going to dive into long-term care. So if anyone has any questions about long-term care, I definitely encourage you to come to my April 20th presentation. All right, so let's start from the basics. What is estate planning? So estate planning is the process of planning for death or incapacity through legal documents such as wills, durable powers of attorney, and healthcare directives. And those documents that I just mentioned are the essential estate planning documents that everybody needs. So most of you are probably familiar with what a will is, transfers property at death. Durable powers of attorney allow you to have another person called an agent to make medical and financial decisions for you when you are unable to. And then finally, your healthcare directive, also known as a living will or an advance directive. And that gives you the ability to indicate to doctors whether you want artificial nutrition or hydration if you're at an end of life type situation. Right, so going a little more in depth into each of those documents. So wills allow you to describe how you want your money or property transferred when you pass away. There's a few important components of wills. A lot of my clients ask about tangible personal property. So Washington gives you the ability to make a handwritten list of tangible personal property. So we're talking about jewelry, tools, furniture, vehicles, oddly enough, are included as personal property. Other things like that. So Washington gives you the ability to have a handwritten list. And this is something that I really like because of how flexible it is. And I always give my clients a blank list that they can fill in if they choose. And you can add things to it. You can cross things out. Pre-COVID, and hopefully post-COVID and not too long, my recommendation to most of my clients had been to have the kids over for Thanksgiving or Christmas and ask them what personal items of yours they want. This is especially true when you have multiple children. You would be surprised at how much kind of grief and discord arguing over personal items can cause in a family. I think there's a lot of emotional value attached to those as opposed to monetary value. So my rule of thumb is if you know of any items that are likely to be argued over by your family members, that either you give them to your family members ahead of time before you pass away, or you specifically list them out in your list of tangible personal property, because otherwise it's kind of up to the executor slash family to decide, and sometimes that can get nasty. Another really important component of a will is the residue. So the residue is everything else that's left over after all debts have been paid off and personal items have been distributed. So I always view that as kind of the pot, and that's where you can list generally who you want to inherit. Sometimes people will include a special bequest. For instance, if they want a caregiver child who's been living with them in their home to inherit, then they can list out that child as specifically getting the home after they pass away. But generally, it's money. If there's no attachment to the house, then the house can be sold or what have you. There's a lot of different options, but I typically recommend either if the client has 4 children, have the residue go to their 4 children equal shares, or maybe 10% to 2 different children, and then yes 40%. Yes, that adds up to be 100. to the other children. But you want to think of terms in terms of percentages generally, as opposed to amounts of money. And that's because you never know how much money you're going to have when you pass away. Now, a common misconception about wills is that they allow you to avoid probate. Wills do not allow you to avoid probate, but they do make it easier. And I promise later on in this presentation, I will talk about probate because I know there's a lot of questions, a lot of misconceptions about it. I will get to that, but I want to lay the framework for the other estate planning documents first. All right, so durable powers of attorney. Durable powers of attorney are it's the most essential component of estate planning that you can have. And just to back up a little bit, I have some people tell me that, oh, I don't need to do estate planning because I don't have an estate. My answer to that is if you have two pennies to rub together, you have an estate. So it's really important to at least get kind of the basics, the will, durable power of attorney, healthcare directive. So durable power of attorney allows you to appoint someone to make medical and financial decisions for you when you're unable to. This can be one document or two. And what I mean by that is you can have a general durable power of attorney, which includes both medical and financial decisions, or you can have a durable power of attorney for healthcare and a durable power of attorney for finances. No, um, no way is more correct than the other. My preference is to have one for healthcare and one for finances. And I do this for a couple reasons. First, it gives the principal, so that's the person who's creating the document, to appoint one person to make healthcare decisions and one person to make financial decisions. Sometimes you have different people in your life who have different strengths. You know, let's say you have a child who's a nurse and a child who's an accountant. Now, realistically, you're going to want to have the nurse probably make medical decisions, and you're going to want the accountant to probably make financial decisions for you. So that gives you the option, the flexibility if you have two different documents. Now, the one downside with having one person make medical decisions, one person make financial decisions, is that at some point they are realistically going to have to work together. So you want to be sure that you have people in there who get along. And the main situation where they would have to work together is a long-term care setting. So let's say that you do need to go into an assisted living facility or a nursing home. Realistically, the person who's making healthcare decisions is going to say, okay, I want my relative to go into this really nice place, you know, that's best suited for them based on personality and based on the principal's medical needs. But you may have the person who's making financial decisions say, oh, no, 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 we can't afford that. So then there is the potential for arguing. So you want to be sure if you have two different people that they get along. Now there was before I dive into that, a common question that I get is, can you have multiple people serving at the same time? And normally what someone means by that is, can you have joint agents? So let's say two people making financial decisions or two people making medical decisions for you at the same time. My general recommendation is that it is a bad idea because once again, you run the risk of having them disagree. And if they disagree with each other, then you are looking at potential litigation and worst case scenario, a guardianship down the line. And that's something that we're always trying to avoid if at all possible. And a lot of my practice is trying to keep people out of court. You know, I am a planner by nature, and I'm always trying to help clients get in the best position they can so that they never have to see the inside of a courtroom. Because typically when you have to go to court, unless it's brief probate, and I'll explain that in a little bit, then there's something really wrong. You want to try to avoid that as much as you can. Now, there was a significant change to the durable power of attorney statute in 2017. And that the effect that that had is now you need to list out pretty much every single power that your agent has the ability to do for you. This is especially true regarding financial decisions. Prior to 2017, a lot of the durable powers of attorney had very broad language in them saying my agent can do any and everything having to do with real estate. That's not sufficient anymore. You need to list out all the different real estate powers, different contract powers. Geez, there's a ton of different things. Now there are some things that if a durable power of attorney does not specifically state, your agent cannot do for you. Key ones are giving away money or property, changing beneficiary designations like on your IRA or 401k. Let's see, those are the kind of big ones. Oddly enough, though, those are ones that my clients will very often restrict because it does, if you don't trust your agent, really does leave you wide open to some potential issues down the line. And that's another big thing with durable power of attorney, especially durable power of attorney for finances, is that you really, really have to trust the person who's making financial decisions because they have the ability to have access to all of your finances. And so unfortunately, there is the very real risk of them going in and cleaning out your bank account. So it's really, really important to be sure that you trust the person. Now, there are laws in place to go after somebody if they do that, but they're not robust enough. And in my opinion, they don't catch enough people. So just a big word of caution that you want to be sure that you trust your agent. Now, durable powers of attorney are no longer in effect when you pass away. For healthcare decisions, that makes a lot of sense. A lot of people get confused with that regards to financial decisions. So there's kind of a tough gap sometimes between when somebody passes away and when different financial decisions need to get made. So very often you have decisions such as paying for funeral, burial, cremation, those types of expenses. So there's nobody officially appointed for you right after you pass away. So then either it would fall through a revocable living trust if you are the backup trustee, or if it's just through will, then there's a gap of time that you have to wait until probate is officially opened. And I'll talk about this in just a second. You can appoint somebody to make final funeral arrangements for you, but people don't always do that. So a rule of thumb that I have, and this is, of course, if it is relevant and something that works well for you and your family, is to maybe list one of your kids as being a co-owner of, let's say, a small savings account, maybe that has $10,000 in it or something similar to that. And so with a child as a co-owner, then they can immediately access that money to pay for final arrangements. Sorry, I've deviated just a little bit. But going back to the slide, banks will require a guardianship if you don't have a durable power of attorney in place. And this even applies to spouses, especially if there's only one person's name on a particular bank account, or let's say IRAs. IRAs are almost always only owned by one person. So if you if the person coming after you needs to access that for any reason, and typically there's some unusual circumstances that can arise, so you really want to be sure that you have this in place so you don't end up needing a guardianship. And I'll talk about guardianships in a couple minutes. It'll help make more sense. So going on to a healthcare directive. A healthcare directive, you've probably heard it as a few different terms. Healthcare directive is the one I prefer because I think it helps describe it a little bit better. But it's also known as an advance directive or living will. It only applies when two doctors have made the determination that you are in a permanent unconscious condition or have a terminal condition. So that basically means that you are brain dead, in a coma, never going to wake up, never going to recover. If there is any hope of you being able to survive without, being intubated or being hooked up to any other life support machines, then this does not apply. The kind of crass term for it, which actually does a good job in describing it, is the pull the plug document, because that's really when it kicks in, when it's time to pull the plug. And it allows you to indicate whether you want artificial nutrition or hydration. It does work in tandem with a durable power of attorney for healthcare, because any durable power of attorney for healthcare is going to give your agent the ability to consent to withdrawal of life-sustaining treatment. Now, there is some confusion sometimes with a healthcare directive. So if let's say you are in a temporary coma and you're going to come out of it, then this doesn't apply. And I'm actually just gonna look at myself really quick. So I'm gonna put my screen down a little bit. I'm not sure if you can see too well, but I actually have a trach scar. So the reason I'm using that as an example, obviously I am alive and well, everything's fine, but many years ago I did need to be intubated for a major health crisis. Now, and I did have to be put in a medically induced coma. So at that time I was 21. I had never even heard of anything like this, but even if I had been a little bit older and maybe had my ducks in a row like this, the healthcare directive still wouldn't have applied because my doctors knew I was going to come out of it. Now, if they had done a bunch of brain scans and there hadn't been any brain activity, that's when this would apply. So as long as there's no hope of you coming out of it, that's when this would apply. All right, going on to the next one. So the Death with Dignity Act. This is also kind of colloquially, I can never say that word, also known as the assisted suicide. So it's where you can choose to pass away. And you have to have been diagnosed as having less than 6 months to live. And the way the statute is right now, it is very difficult to carry this out. And the reason is has to do with the different requirements. So the patient themselves has to make 2 requests for medication 15 days apart. You have to have been, like I said, diagnosed as having less than 6 months to live. You have to be mentally competent, and you have to self-administer the medication. So those 3 things have to come together in order to carry this out. Now, there is a bill currently in front of the Washington State Legislature that is going to make it easier to carry this out, but I don't know if that's going to end up passing. It may not, because it's fairly controversial, and I think just a lot of people, a lot of Congress people really don't want to touch this. But just know that this is an option. It's difficult to do, but it is an option. All right, so then let's move on to guardianships. Guardianships are a last resort. It is a court process to determine whether or not somebody is incapacitated. It's a doctor is not the one who makes that determination regarding a guardianship. It's the court. Now, definitely doctors do give opinions, but ultimately it is the court's decision whether or not somebody has capacity. So kind of the general process is that an interested party could be anyone, could be a spouse, could be a care facility, could be an adult child. They bring, or and actually for people with disabled adult children, it could be their parent. So an interested party brings a petition to appoint a guardian for an alleged incapacitated person, AIP. Then a guardian ad litem is appointed by the court to conduct an investigation. So despite how it sounds, a guardian ad litem is not actually a temporary guardian. They're more of an investigator. And then the GAL at that point will make a recommendation after they conduct an investigation about whether the AIP is incapacitated, whether there are any other alternatives to guardianship, and finally, who should serve as guardian. So if you have a durable power of attorney in place, the great majority of the time, you will never need a guardianship. So durable powers of attorney are all about preserving the rights of the principal. With guardianship, rights tend to get taken away. And I actually have a case going on right now where we are seeking guardianship over my client's spouse who developed dementia and unfortunately did not get a durable power of attorney in place. And so the husband needs to be able to legally make decisions for her. And this is the only way that it can be done because she did not get a durable power of attorney in place, unfortunately. Now, next year, actually, there is going to be a complete overhaul of the current guardianship procedure. And this has been really, really controversial in my circles. I am chair recently of the Public Policy Committee in through the Washington Academy of Elder Law Attorneys. So I'm following legislation pretty closely, and my predecessor has been in strong opposition of the new guardianship statute because Washington's pre-existing guardianship rules are pretty robust and they're pretty good about being sure that the AIP's rights are being preserved. And a big concern that he has and a number of us also have is that in certain situations, an emergency guardian can be appointed without the person's knowledge. Now, it can't, I believe, I just recently read it. I think the person has to be notified within 48 hours that an emergency guardian has been appointed. But I just personally, I disagree with that. I don't think anyone should ever have a guardian over them without their knowledge. And especially with elder abuse always being a bit of an issue, that in that 48 hours, if the emergency guardian isn't appropriate and isn't doing what they need to do, a lot of financial harm can come to it. So that's just my 2 cents. That's my opinion. I hope I will be proven wrong, but that's the way the statute stands starting next year, and I suspect there will be a lot of tweaking to it as it gets put into practice. Okay, so there are some other important estate planning documents that are suitable for some people, not suitable for others. First document is called a POLST, and that is a physician order of life-sustaining treatment. So some of you may have that on your fridge. It's a bright green form that your doctor signs, and it specifically applies to paramedics and other first responders. And as the title says, it is a physician order. So a doctor signs that along with the person it affects, or actually the person who's making healthcare decisions can sign it as well. And that gives instructions to paramedics if you do not want any and all life-saving measures. So the default law is that paramedics are required to do everything possible they can to resuscitate a person that they find in an emergency situation. So if somebody has a heart attack, for instance, somebody calls 911, the paramedics are required to do CPR, inject different drugs to try to resuscitate them that way, sometimes use the paddles, unless they see a pulse. So if they see a pulse, then they'll know that the person does not want any life-saving measures, or sometimes you can limit what life-saving measures the paramedics take. And I'm saying paramedics, but it also applies to an emergency situation where you're in an ER at the hospital. Unfortunately, the durable power of attorney does not apply to paramedics in that situation, and I believe it's because it has to do with federal law, which overrides state law. So paramedics have that duty unless they see a pulse. A big issue that I see with pulses is that they are not properly signed. So both the person it affects, or their agent, and the doctor have to sign on the front and back. If they don't, it is not, it's improper, and the paramedics may choose to not abide by that. So if you or your loved one have a pulse, you want to be sure that it's properly signed. And there was a law change over the last several years where now you can have multiple copies of this. You used to only be able to have it as one copy on very specific paper, but now it can be just kind of a plain copy. I definitely recommend having the bright green form as kind of your primary, but some people want to, when we could go on vacation, would take it with them, on a plane, or in their wallet or purse if they're going on a drive. So just know you can have multiple copies of it. Another document you can have is a community property agreement. So most of you have probably heard that Washington is a community property state. So that means that there is the presumption that all property that is acquired by an individual before or after, or rather when they are single, so not married, is presumed to be their own separate property. And any property that they acquire during marriage is presumed to be community, so jointly owned with them and their spouse. Now, the one big exception to this is inheritances. Inheritances are presumed to be the individual, the separate property of a person, whether they are married or single. So how that plays in with a community property agreement is a community property agreement will convert all separate property into community property. And the practical effect of that is that after the first spouse passes, it gives the surviving spouse the ability to access any of that deceased spouse's separate property. If they if they had a bank account that was only in that deceased spouse's name, they can access that. And it also gives them the ability to take the deceased spouse's name off of any jointly owned assets. So community property agreements, they are a simple document that can really make things a lot easier after the first spouse passes. These have to be recorded with the county. And I do a lot of Medicaid and long-term care planning. So I always across the board tell clients to never record this document until after the first spouse passes away, because it can result in Medicaid ineligibility. And my next comment is not going to make much sense now, but please come back to the long-term care presentation because it'll make more sense. With Medicaid, you're trying to divide assets. So that's why community property agreements being recorded are not a good idea when Medicaid is potentially an issue. Another document is disposition of remains. So in Washington, there is a hierarchy of people who get to be in control of what happens to your remains after you pass away. So first it's your spouse, and then it's the majority of your kids, then your parents, then your siblings, and so on down the line. With a disposition of remains, it gives you the ability to appoint one person to make final arrangements for you. Now, if you have prepaid funeral arrangements, very often you'll do a document similar to this at that time. So this isn't always something that you need to do separately as part of the rest of your estate planning. But sometimes this document can be really, really useful, where you don't have much of any family, or where I see it the most often is where you have children who don't get along. So if that situation occurs, and let's say you have two kids and they don't get along, the majority of your children have to agree in order to make final arrangements. And if you have two kids who don't agree, then just things get really, really nasty, and likely litigation would be involved. So disposition of remains can be good for some people. It's not suitable for everybody, but just know that it is an option. All right, so let's move on to trusts. So there's two main categories of trusts. And keep in mind, I'm just scratching the surface on trusts because there's tons and tons of continuing education just for attorneys on trusts. So we're just looking at it from the 30,000 foot level. So the two main categories are standalone and testamentary. So standalone, pretty self-explanatory. It's a trust that kind of stands on its own. Testamentary trusts, testamentary is just a fancy word for having to do with a will. So some of you may have heard letters testamentary, and then testamentary trusts just refer to trusts contained within a will and only go into effect at death. There are two main, there's two ways to think of standalone trusts. I was about to say categories, but revocable living trusts are kind of its own category. Now, there's about 1 million different kinds of irrevocable trusts, but revocable living trusts, that's kind of that's its own thing for its own category. I'm not saying that well. It's kind of self-explanatory. It can be revoked or changed during your lifetime. It can help avoid probate if that's something that you choose to do. And it can also avoid disinheritance of stepchildren. So let me distill those a little bit. So you'll hear me talk in just a little bit that probate in Washington, not that big of a deal. So you're not always needing it to avoid probate just in Washington. Now, I like revocable living trusts for clients who have property in multiple states. Now, like I said, avoiding probate in Washington, not that big of a deal, but if you have property in multiple states, you really don't want to have to go through multiple probates. It turns into a headache and expense. And so that can be a way to help avoid probate for a revocable living trust. I also like revocable living trusts for married couples that have children from prior marriages, and to kind of make a subcategory of that, it's married couples who got married when their children were adults. Now, children who were minors when their parents got together, I can't say this 100% of the time, but very often what I see is that the step parent tends to have a close relationship with his or her stepchildren because they basically helped raise them. Not always the case with stepchildren. So you run the risk of when one spouse passes away, if you just have a will in place, the other spouse can go in and update his or her will and essentially disinherit the deceased spouse's kids. This happens more often than you might think. So that that can be a really good reason to use a revocable living trust. Now, revocable living trusts are problematic for people sometimes, and that's because in order to avoid probate, you have to what's called fund the trust. So you want to view the trust as a box that you put things in. So if you're doing a revocable living trust, you would need to get a new deed for your house to transfer your house into the trust. You can transfer large bank accounts or investment accounts into a trust as well. Typically not IRAs or 401ks or life insurance. Anything with a beneficiary designation, you can't typically transfer into a trust. But where I see that the biggest issues is somebody will create a trust. 20 years ago, they come in to see me just to update their estate planning documents. And one of the first questions I ask them is, well, what's in the trust? And a lot of people will just kind of get a blank look on their face and say, well, I didn't know anything needed to be in the trust. So they have an empty trust at that point, which means that they have spent a lot of money for a very fancy paperweight. Trusts in general are fairly expensive and complicated to set up. So if you're going to do one, you want to be sure that you're going to be on top of it, or else you've spent a lot of money and you still need to go through probate. And a situation that I've seen multiple times is that somebody will properly fund the trust 20 years ago, but things change over time. Maybe they purchased a new house and they forgot to put the house into the trust, or maybe they changed financial advisors. And so a mutual fund that was with Edward Jones is now maybe with Schwab, and they didn't put that that investment account back into the trust. So trusts, I see sometimes they can be helpful, but a lot of times they're a little bit more trouble than they're worth. Irrevocable trusts, kind of self-explanatory, they cannot be revoked or changed. The primary purpose of irrevocable trusts is to protect assets from taxation and creditors. There's a bunch of different kinds of trusts. They can be helpful for estate tax protection. Now, Washington does have an estate tax that kicks in at 2.2 million. Especially for a married couple, it's pretty easy to, shield 4.4 to 5 million just by doing some gifting, but that's above and beyond the scope of this presentation. But there are some really fancy, expensive, irrevocable trusts that can protect you from having to pay estate tax. There is a federal estate tax that kicks in at $11.5 million per person. There has been some thought that Biden may try to reduce that threshold, but I think COVID is just, it's kind of all consuming right now. So I think that's been put on the back burner at the moment. But I still think Washington's estate tax is going to be more of an issue for people in general, because the federal estate tax has almost always been higher than the state estate tax. You can also have a trust to assist with Medicaid eligibility if done more than 5 years in advance of needing Medicaid. I will dive in more to this type of trust next month when we talk about long-term care. Just know that that is an option. Oh, really quickly, I had been made aware that somebody had emailed a question ahead of time that asked, can a revocable living trust help protect your assets from Medicaid? The short answer is no, because it can be revoked or changed. And it's considered a see-through asset. Any assets in a revocable living trust are subject to Medicaid. And like I said, I will go into this a lot more in depth. I know I'm just kind of hitting on it, hopefully not creating too much confusion, but it will make more sense when I dive into Medicaid rules. All right, so there are a few different types of testamentary trusts, and testamentary trusts, as a reminder, are those contained within a will. These can also be sub-trusts of a revocable living trust as well. So you can put these kinds of trusts in as kind of a subset of a revocable living trust, or rather contained within it. One of the more common ones that I do is a special needs trust. So I am a big fan of special needs trusts, and because of my practice area, I will put them just kind of as a rule into wills and revocable living trusts, even if you don't know for sure if an heir is likely to need it. And that's because it can help protect the public benefits of somebody who receives an inheritance. So typically for public benefits, Medicaid, SSI are the two big ones, food stamps, really just anything like that that is resource contingent. So limits how many resources, how much money you can have. Unfortunately, if you don't have a special needs trust in place and an heir is on government benefits, then they can lose those benefits because all of a sudden they have too much money. With the special needs trust, it's basically an account that the money gets put into of the heir's inheritance. And so whoever's managing the trust can take money out to pay for things that the government benefits don't cover. So I'm a huge fan of special needs trusts. They can really do a lot of good. And the nice thing about them is that they can be present in a will or trust. And if your heir ends up being perfectly healthy, or maybe they're receiving a huge inheritance and they want to get off of the public benefits, they are not obligated to use the special needs trust. Other common testamentary trusts that I do a lot of are educational and spendthrift trusts. And very often I've actually been doing a combination of the two. So a situation would be, let's say you have a younger child or grandchild, maybe they're not quite 18 yet. You want to have them use some of their inheritance for college, but then, maybe if they graduate college when they are 21, they're still not going to be maybe that financially savvy or financially responsible. So you can do a hybrid of an educational and spendthrift trust, where you say that, while the heir is in school, money from the trust can be used to pay for their education. But once they graduate, then, you know, maybe they get a monthly amount of $1,000 or $2,000, and then, hey, at age 25 they get half of the remaining, and then at age 30 they get the other half. Sometimes I do pure special needs, or excuse me, pure spendthrift trusts for adult children who are just financially irresponsible. You know, they could be 30 or 60. You know, I've seen that a number of times, and that's when you can say that, okay, they only get $1,000 or $2,000 or whatever amount you choose per month until the money is gone. So just know that there's lots of different options for how people can get their inheritance doled out. All right, so what you all have been waiting for is probate. So let's dive into that. Probate is the legal process of paying off debts and having heirs inherit from you when you pass away. So probate is a legal process. I'm just checking. Okay, so I'm getting kind of close to being done, and I think timing's good. So probate is a legal court process that typically lasts 4 to 6 months. Now, we have one of the shortest in the country in Washington. Probate has to last a minimum of 4 months because that's how long creditors have when they are properly notified to make a claim against the estate, or they are forever barred. Now, I say 4 to 6 months because, you know, heirs rarely get done exactly on the 4-month mark. There's normally just a few little things that need to be taken care of afterwards. There's very little court involvement. Typically, my client will never need to see the inside of a courtroom, or in the case of COVID, everything's being done via Zoom, which is kind of interesting. But typically, I would just appear at in front of the judge for 5-10 minutes, kind of go over what the deceased person had as far as assets and debts, and request that my client as the executor be officially allowed by the court to carry out probate duties. And so at that point, unless there is a family issue, or unless, knock on wood, this has not happened to me, unless the heir had, or excuse me, unless the executor had a felony that they didn't tell me about, then the court will almost always say yes. Now, keep in mind, if you have had any sort of felony on your record whatsoever, you are not allowed to serve as executor. And I use the term executor because most people are more familiar with that, but the legal official terminology is personal representative. The main ways to avoid probate are as follows. One is you have an estate that is worth less than $100,000. And sorry, there's a typo on that. So what I mean by estate are having assets subject to probate. Anything that has a beneficiary designation, IRAs, 401ks, life insurance policies, those are really common ones. Washington does also have what's called a transfer on death deed. So those, that's basically a way to put a beneficiary on your home. And so it's a new deed that gets created, and it is revocable. So there's some wiggle room in there, but you basically list out who you want to inherit your home after you pass away. It does not give them any, it doesn't give that heir any current interest in the house, only after you pass away. So have to worry about the situation where if you were to have a falling out with them, that they would be able to kick you out of your home. That doesn't happen with the transfer on death deeds. So those can be helpful. I, however, really only recommend them to clients if they are in their forever home. If they plan on selling their home at any point, I typically don't recommend it. I mean, there's nothing wrong with doing it, but it's kind of a waste of money because you would end up having to revoke that. Another way to avoid probate is to have a community property agreement. So I mentioned that earlier, that is something that a married couple would have filed with the county, converts all assets that are joint into, or rather gives the surviving spouse the ability to take the deceased spouse's name off, and converts all separate assets into community. And just going back to the estate worth less than $100,000, if, let's say, you would put your kids' names on everything, but there was one bank account that was worth $5,000 that you forgot to put their name on, then assuming you don't have any debts when you pass away, your kids could just fill out what's called a small estate affidavit and give it to the bank, and that gives them the ability to access the property. Another way to avoid probate is to have a revocable living trust, and that's assuming that it is properly funded. And then you can also have only assets that are not subject to probate. So this would be a situation, let's say you were in an apartment that you rented, you had your kids on all of your bank accounts, and you had them listed as beneficiaries on, your IRA. So at that point, there are no assets subject to probate, and so the kids would get the your assets directly. And then one final way on here to avoid probate is to have an insolvent estate, and that means having more assets than debts. So when you pass away, creditors always get first dibs on your assets. So that means that you have to pay any creditors off before your heirs can inherit. And sometimes somebody will pass away really only having personal items, and in that case, there's really nothing to inherit. And let's say they had a high credit card bill, they had next to no money in the bank. That's when the credit card companies will go in and argue in front of the court to see who gets to get paid first. And I never do insolvent estates that has to do more with litigation, which I try to avoid. So I will always tell my client, just, get the personal items that you can, that can't really be sold, and then walk away from it. Now, I want to talk about trust administration. And I'm specifically talking about revocable living trusts. So I have a lot of people kind of say that, oh, I want to make it as easy for my kids or my family members as possible when I pass away. And a lot of people think that that is done via a trust. I would disagree with that. And that's because trust administration will have a lot of the same components as probate. So you still have to pay off debts. You still have to determine what assets the deceased person has. You have to clean out your home, distribute their personal assets. You have, if the home is owned, either you have to sell it or transfer ownership to an heir. You have to distribute money to heirs. You have to handle family disputes, if any. And then you also have to file tax returns of the deceased person and the estate or trust. The main difference between a revocable living trust and probate is that you don't need court involvement. So for the clients of mine who want to make it as easy on family members as possible, I would say try to have your family members listed as transfer on death or beneficiary designations, because they will get the assets directly after you pass away without having to do any court involvement or really dive into a lot of the administration. All right. So That is all I have. I'm going to stop sharing right now. I've been hearing a lot of dings, so I'm wondering if that, if people are adding to the chat. I'm not seeing anything in the chat, so I'd like to turn it over to whoever's managing the questions.
Yeah. So I